night or broad daylight, she's bringing the truth into the fight. Shining a light where the shadows creep, for the lost, the stolen, the ones who will weep. She won't turn away, she won't back down, even when the loony clowns come round. Threats don't shake her, lies don't win. She stands for justice, right till the end. Want the truth, want the best, wanna be safe as you chat. Find kids true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Chase fame, some chase views, but she fights for those with nothing to lose. For the kids who vanish without a trace, she won't stop till she cracks the case. They try to silence, they try to scare, but truth don't break and she's still there, calling out monsters, showing their game. Justice comes when you speak their name. Want the truth, want the best, wanna be safe as you chat. Find kids true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Need a voice, kids stand strong, she makes the choice. For victims gone, for those in need, she's fighting hard, she won't concede. Want the truth, want the best, wanna be safe as you chat. Find kids true crime, it's worth your time. She's got your back, she's on the
That is one of the best songs on TikTok or on YouTube for intros. Yes, Viper wrote that for me. Good day, mate. Good day, mate. I know you fell asleep. I even said something. I knew you, and I said she's 2 hours behind us in time. So there's that. Hello, people in the bushes. So I did take a nap, guys. For 45 minutes. Yeah, I sure did. Oh, God. Somebody's sticking up the fucking place. The music did it? Did it? Now I lay me down to sleep. That's on? I tried stick up for you. Oh, okay. Okay. What do you think this little girl's going to get? Now, she don't have a record. I I don't think she's going to get life. Because they were unable to say how baby Evelyn died and cause of death. And the only thing, oh, never mind. I don't want to go back. Yeah, I was. Yeah, it don't work like that. Nope. All right, anytime. It must not start until 1. Let me look. Nala, we don't need to do that. Do we, Nala? Stop it. I know, it's you, cute little girl. Narla? It's Nala, silly. Not Narla. Nala. She got little dog syndrome. Am I showing it? Yeah. What's everybody doing? Four degrees Fahrenheit? I'm patching a hole in airbed. Oh, okay. Did you hear the wonderful news? That's crazy. 4 degrees. I'm not looking forward to that. Oh my God, no. Are you? Are you dealing with Marketplace? I put some stuff for sale on Marketplace. See what happens. What is that smell? Oh my God. I got heater for my dressing gown on. Oh my God. Funny. So tonight at 7:00 p.m. Central Standard Time, we're doing Wade Wilson for you. For ya. Wow. Oh my God. $200 for a pair of jeans. Hello. That's crazy. Hey, but if you could afford it, you go, girl. You go, girl. And no way I would sell them for $25 if you paid that much. Nada. Oh, okay. So there was a huge immigration bust today at the Hyundai dealer in um, Georgia. Over 400 migrants, undocumented, were arrested at the plant. You know what this means? That means somebody within that company, it was a South Korea, yeah, South Korea company owns it. They had to know these people were undocumented. That's over 400 jobs for Americans taken. And then the news is like, oh, never mind. Never, never mind. Too bad. Too bad. Too bad, so sad. Yep. It'll be 10 a.m. Saturday. That's crazy to me. No, we don't do that. You're gonna listen. You're gonna listen, little girl. You're such a sweet little girl. Here we go.
This case will take up is State versus Megan Boswell, 72869. Long debate for sentencing. There was a pre-sentence report filed April the 4th, 2025. A jury convicted Ms. Boswell of first-degree murder in count 1, first-degree murder and perpetration of felony in counts 2 and 3. The jury sentenced her to life. The jury also convicted her in count 4 of aggravated child abuse, count 5 aggravated child neglect, count 6 tampering with evidence, count 7 through 17 false report, count 19 abuse of corpse, count 20 failure to report the death under suspicious, unusual, or unnatural circumstances. So we're here on counts 4 through 20 for sentencing today. Is the state ready to proceed?
We are, Your Honor.
Ken's ready to proceed.
Yes, yes.
Because sentencing, the first thing that's up, the state has to vote.
Judge, how are you going to handle the pre-sentence report that we made?
Because of the nature of this case, it's going to be exhibit number 1. I normally don't make any exhibit, but I think in this case.
Fine with me. Thanks, Judge.
Somebody have a copy of it? It's not been marked up? And if you don't, I've got it in the file. I just got to find it. Which file it's in?
Judge, we have a clean copy.
General, the state having approved.
Yes, Your Honor, the state will call Sheriff Jeff Cassidy.
Everybody hand, state your name, please.
Sheriff Jeff Cassidy.
Solemnly swear upon testimony about to give is true, all truth, and nothing but the truth.
Tell the court your name and where you're employed,
Jeff Cassidy, Sheriff of Sullivan County Sheriff's Office.
and how long have you been with the sheriff's office?
Been with them a total of 29 years. This is my 7th year as sheriff.
Okay, And so that means you were sheriff in 2020 during the time of this investigation. Is that
Yes.
right?
Yes, ma'am.
And I'm gonna take you back to February 2020. Was Sullivan County the first agency to be involved in the investigation of missing child Evelyn Boswell?
Yes, ma'am.
Can you tell me briefly how Sullivan County how the investigation started?
Missing child at first, and then once we found out that the last time the baby was saw was in December, we knew it was already behind the curve there. We was probably 2 months away from utilizing the resources that we needed to rescue or recover a baby Evelyn.
Okay. How old were you told Evelyn was the time the investigation began?
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives and everybody that was responded to this scene and responded to all the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
Okay. When you say around the clock, was there 24/7 coverage
Yes, ma'am.
of this? And are we talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
It's approximately 18 days.
Yeah, from about February 18th to March 6th, I've looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime.
Plus overtime.
Okay. So let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, Federal Bureau of Investigation, Virginia State Police, SBI,
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up in North Carolina and other states, Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, tried to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
And is the virtual command center, that's where the tips would come in to decide how to then send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. We utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana, from what I remember, and we had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay. She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So in preparation for today's hearing, you were asked to review Sullivan County records regarding this investigation, is that right?
Yes, ma'am.
And the records that you reviewed, were they all maintained by the sheriff's office?
Yes, ma'am. Just the Sullivan County Sheriff's Office.
And the purpose of those was to come up with the manpower that was used,
Yes, ma'am.
to get an approximate amount of manpower and overtime hours, is that right?
Yes, ma'am.
What if the defendant had told the truth on day one?
Yeah,
Objection calls for speculation.
I can ask you a different way. Would you have found Evelyn if the defendant had told the truth on day one?
Objection
Yes.
calls for speculation.
Sustained. Yeah, it needs to be framed. Too wrong.
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could, eat and still work. And they all pulled together during that time and just showed tremendous outpouring support for our entire agency. And, across the nation, really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And, whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. And, just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. They tried to send some home, and they said, no, I'm not going home. I'm going to work on this case until we find the baby.
Okay, no other questions? Does
Thank
answering
you.
questions Mr. Scott has for you?
I don't have any questions.
Thank you. Thank you.
Stay with call, take the last price. You're Matt Price, is that correct?
Yes, sir.
What is your position at the sheriff's department?
I'm lieutenant in criminal investigations.
And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
This case was assigned to me as the lead investigator with the sheriff's office. So I was the lead investigator.
And you worked, the sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including TBI, is that correct?
Yes, that's correct.
Okay. David Gratz at the time, also two of you
Worked it.
worked extensively. That'd be
Yes.
correct. You familiar with the evidence that was collected in the case, the discovery of the body of the victim, Evelyn Boswell?
Yes.
Lieutenant Price, I'm going to hand you some photographs. I'm just going to do this one at a time so for the sake of getting these exhibits in. I'm going to hand you the first photograph, ask you if you can show us, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evan was located.
And is that a true and accurate depiction of
Yes.
that scene?
Yeah.
Judge Woody moved to make that exhibit number one to this hearing, two, I'm sorry. And I don't know if it's helpful, but that is what the trial was introduced as exhibit number 15. If that's helpful or would create confusion.
It's just gonna be exhibit one from that sentence.
Two. Do you recognize what's shown in the photographs just been handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the one of the bags had been moved off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would make that exhibit 3 for this hearing. Okay. Lieutenant Price, would you take a look at the photographs being handed to you and ask, or again, ask if you can identify what's shown?
Yes, this is a picture of the inside the trash can with the blanket removed where you can see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
Judge, we think that exhibit 4 for this hearing. Do you recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evan was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
So the body has been removed from the trash.
Correct.
bag.
The body's been removed from the trash bag. It's in the trash bag with trash in it. Baby Evan is laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 for this hearing. Do you recognize what is shown in the photographs that's been handed to you?
Yes, I do.
And what is that? Picture of it.
This is the body of baby Evelyn after she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil wrapped around where her head area was.
Judge, we would make that exhibit 6 to this hearing. Do you recognize the photo that's just been handed to you?
Yes, I do.
What is shown in that photo?
And this is baby Evelyn laying in, still wrapped in blankets laying on a body bag, with her arm exposed, showing the onesie that she was wearing.
Is that photo, that one of the photos that was taken at the time the body was recovered?
It is correct.
Judge, we would move to make that exhibit 7 for this hearing. Lieutenant Price, do you recognize what's shown in that photo?
Yes, I do.
What is that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the position of her head and how she was laying when the blanket was removed.
Judge, we move to make that exhibit 8 for this hearing.
those timers going on. They really need to adjust their volume.
One more photo and ask you to identify that photograph, please.
Yes, I can. This is a picture of Evelyn, one of the last known pictures. We know that when she was alive.
If we could make that exhibit number 9 in this area. Thank you, Lieutenant Price. If you would answer any questions Mr. Scott has for you.
No questions, Judge.
That's all the evidence.
Judge is Boswell, I'd like to make an allocution.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
No, sir.
I'm sorry. Judge, the state has, prior to this hearing, filed a notice of intent in regards to enhancing factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Ms. Boswell is a dangerous offender whose behavior indicates little, no regard for human life, that she had no hesitation about committing a crime in which the risk of human life was high. That this court should render those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in the trial, as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Miss Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. Detective Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can, so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole and painful part of this is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Megan. Megan chose her life. Megan chose living in the big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter. In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad. Well, then she manipulates law enforcement, it manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in a trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing was necessary to protect the public from further crimes. And I provided the court, as well as Mr. Scott, with the case of State Taylor, which was a case in which a small child had been beaten to death. And then the mother basically delayed in reporting, calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, and the results were fatal. Well, Judge, I really, it does not get any more callous than what the defendant did in this case. You know, she turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly does not get any more callous than that. So the state would submit that both those factors are met and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved in an enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's office, I guess, should be issuing an apology to her the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance because of the one person who should have protected her. For that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on. And we would ask that they maybe run consecutive, Judge. Thank you.
Judge, I guess I'll try to address this in somewhat the way Mr. Harper did, maybe in the backwards fashion. Ms. Boswell had no prior criminal history when this case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything, not run consecutive. She'll be in jail until she's 69 years old. So the court then has to determine, is she, at that point, is she going to be a threat to society? Society needs to be protected from 69-year-old Megan Boswell. The court should, I guess first the court has to consider the length of the sentence. She's a range one offender as to each count. The court should impose I think the sentence is, short of a sentence is as necessary, so the court is supposed to do. To achieve the purposes of the sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole. That's what they want. And we have addressed that issue already in a manner of speaking. I guess practice law 25 years, not the only jury sentencing I've ever done. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. And I know you're not bound by that on these other counts, but I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges. Obviously, they heard the guilt phase on those and convicted her. So I think that is important to consider. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to the dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all those things kind of go together. And I guess the other thing we have to talk about is what counts merge together in a sentence. I would suggest, of course, that the murder counts merge together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. This is Supreme Court decided at 2014. He talks about, cases just like this. Each of these cases, these interviews were basically a continuation of the other interviews. And based on the rule of leniency, the court found that even though in that case, interviews were made over multiple days with different officers, just in this case, they had to merge. And that's what I think should happen here, is all those counts should merge. And I guess finally, I want to address what Mr. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. But I think she's entitled to maintain her defense. She doesn't have to come in here for purposes of sentencing or this, and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for length of sentence. The defendant has a right to maintain their innocence, and to hold that against them and somehow sentence them to more jail time because they don't come in here and say, I did it. That violates due process. It violates the right to trial by jury, the right to appeal. So I would suggest before that the appropriate sentence here should be bottom end of the range. The sentences should run concurrent, and ultimately she should be left with a chance of parole when she's 69 years old. However, that is structured.
Court will be in recess for 15 minutes.
Court is in recess for 15 minutes. Yeehaw. Yeehaw. Court is in recess for 15 minutes. 15 minutes. Okay. Hush up, people. Hush up. Sorry. Now, the judge is going to take in, okay. I have mixed feelings about this. Her age, that's why they didn't do the death penalty, because she was so young. I think she has some kind of mental illness, right? She's very immature. Who really took her life? Who took Evelyn's life? Who really took her life? Okay, we know Megan's a liar. We know that. And how did she die? And you know what? She had a rough, okay. Look at her mother. That's all I got to say. Look at her upbringing. If her mother never would have gotten her back, right? Because if you guys remember, she was in foster care when she was pregnant. Just saying. Anybody got any opinions? Anybody? Oh, I got the worst headache in the whole wide world. I need a new phone, people. I need a new phone. This sucks. I know. And Evelyn was such a cute little girl. I have been on this case since Evelyn went missing. This case affected me greatly, people. Greatly. It messed me up in the head. Let me show you something. Hold on. Oh, come on. Oh, hold on a minute, people. There we go. Oh, I know what I was gonna do. Hold on a minute.
Fix all that.
Okay, let's be nosy. What are they saying? Hold up.
Yeah, it's been a while. Good to see you. Good to see you. Good to see you. We love talking. Oh, I didn't know that. Yeah. Emotional total. Thank you for serving. That's what we just. Right. It's very nice to see you.
I mean, I can turn it off.
I think they forgot that it was whatchamacallit. I can't even think right now. I think they forgot. Like, don't know where my video's at. Shoot. So this is what we're gonna do. This is what we're gonna do, people. Hold up. What's going on here? Interesting. I'm looking for something, and it's not showing up. What's going on around here? I did have it there the whole time, people. Okay, this is so stupid. Sorry, guys. I'm trying to do something to show you guys something. But, things don't want to work out for me right now. But it will. Give me a minute. Where's Dippy at? Where's Misty at? Anybody know? Anybody know? I don't think she's going to get life, and that's just my opinion. Everything's going to run concurrent. Whatever she gets is going to be concurrent. But it ain't going to be life. That's just my opinion on the matter. Who's all in here? Eye for an eye, leg for a leg, breath for a breath. How can it not? She's a sweet little girl. Just a little sweet thing. All right, there we go.
Evelyn. Hi. Mwah. Mwah.
You're a sweet little baby. I think the video of her wearing that little baby shark shirt was like one of the last sightings of her. It was around that time. But see, Megan, I can tell you this, Megan, boys were more important, boyfriends. I can tell you that. And it still is today that way with her. I even sing Baby Shark. Oh, I hate that song. I do. I really hate that song. Baby Shark. Okay, what do you think? Is she going to get life? What do you think she's going to get? I don't think she's getting life. I think maybe the judge is really going to... I don't know about this judge. I don't know about him. It's so stupid. Such a stupid song. Just think, the little kid that sang that made millions and millions and millions of dollars. I wonder where Misty is today. You know, it kind of sucks because at her home, her phone don't work. Life with no rights. Baby didn't get rights. Yeah. Okay, their 15 minutes are up. Yep, 15 minutes are up. 15 minutes are up, Judge. Well, he's got 2 minutes. Okay, he's got 2 minutes. Why would teens be singing the Baby Shark song? I'm just wondering. I'm just wondering. Yeah, she's super young. It's crazy. It's crazy sad. She didn't even have a chance at life. And of course, baby Evelyn did. But what I'm saying is, look at her mom and her dad. Her mom was using up until recently. I mean, come on. She lost her kids because of her using. And then she would get them back and then she would start using again. That foster mom should have kept him. The teens love the songs. Oh,
Judge, I think General Massey was on her way back. Judge, may we approach?
Determining the appropriate sentence for these offenses. The court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made as sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the court, such as sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, with range 1 being 2 to 4 years. The abuse of the corpse is a Class E felony, and failure to report death under suspicious, unusual, and unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of proof was that she was approximately 13 months old when she went missing. Is that wrong?
Her approximate age at death was 15 months old.
At death?
At death.
Okay. So she was 15 months old.
It was 13 years, 13 months old at death. It was 15 months old they assumed when she was reported. When they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state, the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. Defendant had no hesitation about committing a crime when the risk of human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, was required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. If the defendant, because of youth or old age, lacks substantial judgment in committing the offense, proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially, from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, that she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing. When the court weighs the enhancing factors and the mitigating factors, that's how I arrive at or not a verdict, but a sentence. I do want to talk, I want to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those two counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion, in counts 4 and 5, that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge, counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And of course, ruling, I just so clarify, it wasn't a mistake, but at the time it was filed, we would have had all the false report counts. Relying on that criminal history, obviously, since it's so stronger, more duplicitous that doesn't exist anymore. So we're not relying on that.
The court objection. The court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little to no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But it's pointed out in State versus Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the main case is the Wilkerson case, 905 Southwest 2nd, 933, Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 40-35-115 enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a consecutive sentencing is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first, there's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake. A lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravating. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child. The court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 it's found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of the corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar, you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, share, I'll do it.
Judge, I would also like to have this sentencing period as well.
Sentencing hearing will need to be typed up with them. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine, but I'll waive Ms. Boswell's appearance. If that-
Well, what I prefer her to do is appear by Zoom.
That's
If
fine.
if she can, but if not, yes, we'll.
Okay.
All right. All right, that's all.
Well, I was wrong. I was wrong, people. It happens. He threw everything at her. Did you see her glare at the judge on the way out? What's going on that we don't know? I just might have to find out, people. All right, I'm going to go for now. 7 o'clock, we're doing another live. Wade Wilson, new documents. All right. Oh, did you? Clone this judge. All right. Love you guys. Bye.